In this video, I'll try to explain occupiers liability, the torts of occupiers liability in 5 minutes or less. For a longer lecture on this subject, head over to the playlist containing long-form lectures. Occupiers liability developed out of the tort of negligence, so many of the principles will be the same. In short, occupiers liability refers to the tort in which occupiers are held liable for people who, while on the occupier's premises, suffered injury or damage to their property. The law relating to or governing occupiers liability include the common law, but to a very large extent, the law as it was codified in two statutes. Firstly, the Occupiers Liability Act 1957, which applies to lawful visitors to the premises. And secondly, the Occupiers Liability Act 1984, which followed to cover liability for people who are injured due to the state of the premises while they were not lawful visitors, such as, for instance, trespassers. There are a number of definitions that you need to know in order to understand how this tort works. Firstly, who do we regard as an occupier? The law regards an occupier as a person with sufficient degree of control over the state of the premises. So take note that this could be somebody else than the owner or even somebody else than the physical occupier. So, for instance, it could be a landlord or a tenant. Premises are defined as any fixed or movable structure, including any vessel, vehicle, or aircraft. So the premises could, for example, be a boat or even an aeroplane. First, let's look at the Occupiers Liability Act 1957. This act forms the basis for liability towards people who were injured due to the state of the premises they visited and while they were lawful visitors. So lawful visitors would be people who are invited onto the premises by the occupier, or it could be people who had otherwise any kind of permission to be on the premises, such as, for example, a meter reader coming into your garden to read your water meter. Towards these people, the occupier is recognized as having a common duty of care defined in Section 2, subsection 2 of the 1957 Act as being the same as, basically the same as in negligence cases. We use the reasonable man test, which you'll be familiar with if you go and have a look at the negligence lectures that I posted. And that means that the occupier will have to guard against foreseeable risks to the visitor. Moving on to the Occupiers Liability Act 1984, there are a variety of reasons why this was enacted, but it boils down to clarifying the kind of liability that could be faced by occupiers towards people that come onto their land without being lawful visitors, such as, for example, trespassers. It differs from the 1957 Act in that it only covers personal injury due to injuries sustained on the premises and not damage to property. It's also more difficult to prove. So in other words, a trespasser who is injured whilst trespassing will have a more difficult job than a person who was on the premises lawfully. The occupier will only be held liable under the following circumstances. So there are 3 things that need to be proved. 2 of those things are subjective and 1 thing is objective. The first 2 subjective tests is that the claimant will have to show that the occupier was aware of the danger or had reasonable grounds to believe that the danger existed, and knew or had reasonable grounds to believe that people would come into the vicinity of the danger. And finally, the claimant will have to prove that the defendant, the occupier, should have guarded against this risk. So also will need to convince the court that the risk is something that the defendant should reasonably have been expected to guard against. So that, in a nutshell, is occupiers liability. On this last slide, I also give you a handy summary of the main differences between the 1957 and the 1984 Acts.